Good afternoon, everybody. Thank you very much for including me in your session, Dahlia. Thanks, Anne-Marie, and thank you to the interpreter for interpreting my session. I'm really sorry I don't speak very good French. Can you? Okay. Is better? Okay. I'm talking about harassment and bullying in Australia, and what I'm really trying to do here is to show you how fragmented a system can get on a very important issue, and at the end just briefly report on the consequences for employers and workers. So harassment and bullying in Australian workplaces is a very significant problem. There's been recent research by Potter and her colleagues that showed about 9.7% of Australian workers are reported being bullied at work in 2014 to 15. And harassment and bullying is regulated by a patchwork of legal provisions and regulatory institutions, reflecting constitutional complexity. So Australia is a federation. I'll show you a map in a moment, with 6 states and 2 territories and a Commonwealth government. And of course, we have a constitution that divides the powers between the relative legislatures. And secondly, it's complex because of different regulatory silos that have different objectives, and I'll give you some illustrations, with some legal provisions developed specifically to address bullying and harassment, and others are general provisions that you can apply to bullying and harassment. Now, this is where I come from. I don't know if you noticed earlier the big map. You can see that Australia's on the other side of the world from Canada, and it seems like that when you're in a plane. So here's Australia. 6, like Canada, a federation, 6 states. The Northern Territory is a territory together with this red dot, the Australian Capital Territory. And the Commonwealth Constitution determines whether the Commonwealth Government, the Australian Government, has power to legislate for all of Australia, or whether the states and the territories do legislation. Now, this is the gist of my argument. There's a patchwork of legal provisions that regulate harassment and bullying. Some of them, very few of them, actually define bullying and actually focus on bullying in particular. And I'll explain in a moment. There's a guide under the Work Health and Safety Act, and there's an anti-bullying jurisdiction in the Fair Work Commission. But the rest of the provisions apply generally, and if harassment or bullying falls within the categories that are protected by those provisions, then they are addressed. You'll see in the next column that some of the legislation tries to prevent bullying and harassment, others focus on compensation and rehabilitation, there's some that just focus on punishment, and there are others that give other forms of redress. And in the second half of the slide, I just show that some provisions only apply to the Commonwealth Government, where I say yes, Commonwealth, but other provisions in other areas, the Commonwealth has full jurisdiction across Australia. But on the very far, what is it for you? On the very far left-hand side, you'll see that the state and territory governments have lots of legislative powers that apply to issues that have to do with bullying and harassment. And at the very end, I list the number of regulatory agencies. That's the minimum. You can see near the end, I got dazed and confused, and it was quite hard because some of the Australian jurisdictions actually have industrial relations systems, even though the federal government covers most of industrial relations. Okay, now, my area is work health and safety regulation, so I'm going to start there for historical reasons, but also because work health and safety regulation is preventive, and I think that's where you should start. So, work health and safety legislation developed in the 19th century, but it was reformed all over the world. We've all got a similar story about reforms in the 1980s, early 1990s. The current provisions in most of the Australian jurisdictions are in harmonised Work Health and Safety Acts. The standards in those acts operate at 3 levels. There's a series of general duties on persons who conduct a business or an undertaking. We don't use the term employees anymore. On officers, have a duty of due diligence to ensure that the PCBU carries out its obligations, and then workers and others have duties of care to themselves and to others. Now you can see how in broad those would apply to bullying issues and harassment issues. The main primary duty owed by the PCBU is very terse and broad, and the whole idea is to cover all kinds of hazards and all kinds of work arrangements. So The problem with that, as everybody in the room knows, is that most people don't know what to do. They know that they're covered, most hazards and most work arrangements are covered, but nobody really knows what to do. So the Work Health and Safety Regulation gives detail about the kinds of obligations required in that broad general duty, but it doesn't mention psychosocial hazards. It's way out of date in its approach to hazards. There's an approved code of practice, which is the next level down. Approved codes of practice give guidance as to what's reasonably practicable to comply with the duty. There's a broad code on how to manage work health and safety risks, which sets out a systematic approach to manage health and safety. It includes bullying, stress, fatigue, and violence examples. But it's only at the next level down, the fourth level down, there is a guide for preventing and responding to workplace bullying, and it's one of the few documents that actually defines bullying. So bullying is defined as a repeated and unreasonable behavior directed towards a worker or a group of workers that creates a risk to health and safety, and there's an exception for reasonable management action taken in a reasonable way. And then the guide goes on to give systematic approaches to prevent bullying, how organisations can prevent bullying arising at work, and then it gives examples and guidance as to how management should respond to complaints about bullying. That legislation is backed up by provisions for worker representation and participation. They're important because work health and safety representatives have powers to inspect workplaces, to find out about bullying and harassment, in other words, and to actually take action, to issue provisional improvement notices, and to stop work. Unions have rights of entry to investigate contraventions. They're very strong anti-victimization provisions, which are obviously about harassment and bullying of workers and others who are trying to exercise their rights under the legislation. And then the Work Health and Safety Inspectorate has the usual enforcement powers that most inspectorates have, including criminal prosecution. But it's very rare for bullying and harassment cases to be prosecuted. And when they are, they're usually those physical bullying examples, practical jokes, so-called, and initiation ceremonies and so on. The Work Health and Safety Inspectorate is very uncomfortable with harassment and bullying issues because they're soft and difficult and they find them very difficult to address. Now, the next set of provisions are anti-discrimination provisions. They're mainly about compensation, but there are other remedies, as you can see at the bottom of the slide, injunctions, declaratory relief. You can vary a contract, you can reinstate a dismissed worker. The federal statute, the first statute was a federal statute in 1975 on race. There's a 1984 federal statute that covers sex. There's 1992 disability and 2004 age. And the state and territory statute started in 1966, and every jurisdiction has a statute, and it covers the usual attributes that are protected by anti-discrimination legislation. If you search through all of that legislation, and I don't suggest you do, you'll find that the only forms of harassment or bullying that are defined in those statutes are sexual, racial, and disability harassment provisions. Otherwise, where bullying and harassment amounts to differential treatment, then the worker who is suffering the bullying and harassment can claim discrimination and seek a remedy. The workers' compensation provisions are very similar to most Anglo-Australian, most other common law countries. Again, there's no definition of bullying and harassment in those provisions. They provide no-fault compensation for injury or disease that is related to work that result from bullying and harassment. But again, it's because an injury or a disease has been suffered, a mental injury or disease has been suffered as a consequence of bullying and harassment. The first mental stress cases were taken in the early 1990s. Almost immediately, there was an exception put in the workers' compensation legislation that reasonable management action taken in a reasonable way won't result in compensation. Just in case you want to know, about 6% of workers' compensation claims are for mental injury, mental health issues. About 91% of those involve mental stress, and about 27% are for harassment or bullying. The common law has provisions for compensation if there's bullying and harassment, but again, that's not defined. There's just a common law negligence action, and there have been fairly recent cases where workers have been bullied or harassed at work and have been able to claim under the common law for negligence. And it's complicated to explain in a short period of time, so please ask a question later. There are also provisions in the mainstream criminal law to extend stalking, the definition of stalking, to cover bullying. Again, I can't go into that in much detail, but the police investigate and prosecute those provisions, and imprisonment is the possible sanction. I'm going to tidy up quickly, and I won't go through this in detail, but the Australian federal labour law system has always had anti-victimisation provisions ever since the earliest years. Initially, they just protected workers who were involved in the industrial relations system, taking collective action or organising. But fairly recently, they've been expanded to all kinds of adverse action that involve workers being discriminated against or had adverse action taken against them because they're exercising a workplace right. And that's become a very important way of addressing harassment at work. Sorry about the speed, but those are the constraints. I just want to talk about something that actually does focus on bullying, because I feel that I've given you a very vague description of how Australia addresses bullying and harassment. The Fair Work Act was amended in 2013 after an inquiry into bullying at work. And it came up with an anti-bullying jurisdiction within the main industrial relations tribunal, the Fair Work Commission. And it defined bullying as a worker is bullied if an individual or a group repeatedly behaves unreasonably towards the worker or a group of which the worker is a member, and that behaviour creates a risk to health and safety. That's the definition of bullying. Notice it doesn't have to be an employer and an employee that is the bully. It can be a customer, it can be a client, it can be somebody outside the workplace. Again, reasonable management action carried out in a reasonable manner does not come within the definition of bullying. So the bullying must take place while the worker is at work. There must be a risk that while they're at work, the applicant will continue to be bullied by the person identified in the application. And this is a very controversial finding or decision by the tribunals, because it means that if a worker is actually bullied, it goes to the tribunal, but the employer then says, no, we'll implement a proper system to prevent bullying, then the tribunal will probably find that they won't give an order because they will say bullying isn't likely to continue at that workplace. Likewise, if a worker leaves the workplace, then bullying is not likely to continue at that workplace. And there's been a lot of criticism of the Australian system for that. Now, the jurisdiction is preventive, so it's there to resolve issues only, to restore work relationships. The Commission cannot award compensation and cannot punish. And if they're satisfied that bullying has taken place, they may make an order that they consider appropriate to prevent the worker from being bullied at work. At the end of 2017, there were just under 3,000 applications. Only 2,015 of those have actually got to a decision before the Commission. 95% of those have been dismissed for various reasons. So there have only been 7 anti-bullying orders so far. I don't know what's going on under all that. That may be that things are being resolved by conciliation and mediation, so it's hard to tell. We need some research on that. And if you look at the anti-bullying orders, they largely focus on the bullier and the person being bullied. You can't come to work until a certain time, or you can't communicate with each other at work, or you can't send each other emails. Only 2 of them are focused on what the employer can do or should do to address bullying. This is my joke. This shows how simple it all is, right? That's a summary of the provisions that I've discussed. I just want to finish, if Anne-Marie will permit me, just by quoting the House of Representatives Standing Committee on Education and Employment, which conducted that inquiry into bullying in 2012. And they talked about it being a very fragmented and complex system. And I'm actually going to quote what they say, because I think it makes the point that I'm trying to make, and I think our project is looking at very clearly. Navigating through the matrix of regulations can be overwhelmingly complex for employers and workers alike. The overlapping frameworks are frustrating and confusing and are made worse by the variation across jurisdictions in each of those areas. So there's no consistency across the jurisdictions. There's confusion amongst the employers about what responsibilities they carry, how they can meet them, and how they can act on a finding of bullying. There's confusion, frustration, and isolation for workers and their representatives about what rights and remedies they can pursue, either internally within their organisation or externally. None of these frameworks provide a all-in-one protection and response mechanism. And in fact, often bullying or harassment can slip through those cracks. So despite all those provisions, a particular situation can slip through because it doesn't actually fit into the right category. And I might stop there because I might be dragged away if I don't.
Thank you very much, Richard, for this very interesting presentation of Australian legislation.